Good afternoon, everyone. This is Phyllis Carlson-Ream from Action Ohio, Coalition for Battered Women speaking, and I'm delighted that you decided to join us today. Action Ohio is joining with the National Housing Law Project to present this webinar as part of Action Ohio's Safe at Home Housing Advocacy Grant Project, which is supported by the Family Violence Prevention and Services Act grant. In 2013, Action Ohio will also present 4 in-person training events in different parts of Ohio, and we'll be sure to send you notice of these events in the coming months. Thank you for joining us today and indicating your interest in helping survivors obtain and maintain safe and affordable housing. We're delighted to have attorney Malia Schultzman as our guide through this PowerPoint and this presentation, because she has the knowledge and experience to do us a good presentation. Thank you, Malia. Go.
All right. Thanks so much, Phyllis, and thanks everyone for joining us today. As Phyllis said, my name is Malia Schultzman. I'm an attorney with the National Housing Law Project in San Francisco. We are a support center for domestic violence agencies and legal aid programs throughout the country that are working on domestic violence and housing issues. My contact information is on the last slide. So if you're ever in a situation where you need some assistance or support via email or phone regarding a housing issue that's affecting a survivor of domestic violence, sexual assault, or stalking, feel free to contact me and we can discuss and see what options might be available for your client. Or if you're interested in receiving training materials, advocacy documents, or just consulting about other types of advocacy, feel free to contact me. So before we get started with today's presentation, I wanted to go over the webinar interface. On the left-hand side of your screen, you'll have a viewer where you can see my screen and what I have up on my monitor right now. You also have a control panel, and the control panel you can actually make smaller by clicking the double arrows. If it's minimized right now, which it might be for some of you, you can make it bigger by clicking the double arrows again. On today's call, you have the option of either listening by phone or listening via your computer's mic and speakers. Now is a great opportunity to do a sound check. If you can't hear me well, you might want to switch to using your telephone. You just click on the Use Telephone button, and it'll come up with the call and information for the call. The other important thing for today is that we have you all muted due to the size of the audience, but we still want to hear feedback from you and get questions from you. So to do that, you can type your questions or comments into the questions box. The other option is I can unmute you if you prefer to verbally ask your question. If you raise your hand using the Raise Your Hand button, I'll know that you want to talk to me, and I'll unmute you so you can ask your question verbally. Feel free to submit questions throughout the webinar, and at the end, I'll screen through them and see which ones we can get to in the last 10 minutes or so of the presentation. So in terms of what we're covering today, we're going to be focusing on housing authority plans and policies and how they affect domestic violence survivors as well as survivors of sexual assault. We'll discuss how all of you can get involved in that process. And I want to note that we're focusing on housing authorities today. And housing authorities primarily administer public housing and Section 8 vouchers. But I want to tell you that if you're dealing with other types of housing, such as tax credits or project-based Section 8, many of these policies can also be adopted by those types of housing providers. And so while we're focusing on the housing authorities today, much of this information can be applicable to other types of housing. I'll also note that later this week we're offering a webinar on the tax credit program, just a basic overview. And so if you're interested in that, feel free to email me and I can send you the registration info. So why are we talking about this today and why is it important? Advocacy with housing authorities really gives you an opportunity to shape some policies that can affect your client's access to subsidized housing, and in particular the public housing and Section 8 voucher programs. Some of the policies that are affected by housing authority plans include admission to their programs, relocating within public housing or with a Section 8 voucher if you have a survivor who needs to do that for her safety, Policies can help you prevent evictions and subsidy terminations involving domestic violence survivors. And there are several other important areas that we'll touch on. Other reasons why you might want to work on this is that it gives you an opportunity to develop a relationship with your local housing authority, and gives you an opportunity to hold your housing authority accountable to make sure that they are thinking about the housing needs of survivors of domestic violence and sexual assault. Before we get into further detail, though, I want to run a poll and see who's in our audience today. So I'm going to go ahead and launch this poll, which asks, which best describes you? Are you domestic or sexual violence program staff? Are you social services program staff? Are you a housing provider? Are you a legal services attorney or advocate? Or would you describe yourself as being in the category of other? So I can see that you're voting, and I want to give you a few more seconds to vote and share your responses. This is really helpful because it helps both me and Phyllis know who's on the call with us today and how we should target the information. Wow, so this is the first time I've ever had 100% of the audience vote, so that's really exciting. So good job, everyone. All right, so I'm going to share the results. 30% of you are domestic or sexual violence program staff. 27% of you are social services program staff. 17% of you are housing providers. 7% are legal services attorney or advocate. 20% fall into the category of other. So that's great results, and I want to run one other poll. And this is just to help Phyllis and I get a better sense of how many people are actually attending today. So the question on this one is, besides you, how many people are attending this session with you? And again, that's just so for our own purposes, we get a better understanding of actually how many people are in the audience. So it looks like most of you have voted. So I'll close the results and share. All right, so most of you are lonely and by yourself, but actually some of you are sharing the line with others, which is great. 22% of you are watching with one other person, and 4% of you are watching with 2 other people. So with that, let's go back to the substance of the training. So first, I wanted to tell you, what are these plans that we're going to be discussing today? And there may be some housing authority staff on the line during this call, and they'll tell you that there's several different plans that they have to maintain. First one is the annual plan. This is really a template that comes from HUD that housing authorities have to submit with some required attachments. The great thing about this plan, though, is that it has to include, under law, information about how the housing authority is serving domestic violence survivors. And we'll talk about that in more detail later. The other type of plan that housing authorities often maintain is what's called the Section 8 Administrative Plan or Admin Plan. This is the policy that most housing authorities rely on a day-to-day basis to run their Section 8 voucher programs. It sets forth the policies that their staff will consult on a regular basis in making decisions in areas like who are they going to admit to the program and who might be subject to being terminated from the program. The third major plan we'll talk about today is the Public Housing Admissions and Continued Occupancy Policy, or sometimes it's called the Admissions and Occupancy Policy, often called ACOP for short. This is the detailed policy document that housing authorities use in the day-to-day operations of their public housing programs. So with that overview of the 3 major plans, I know your next question is, well, where can I get copies of those plans? For the annual plan, which is the yearly template plan the housing authority has to file, that plan needs to be made available to the public. Once HUD has approved the annual plan, they post it on their website, and I've included the URL on this slide. The other 2, the big policy documents we talked about, the Section 8 Administrative Plan and Public Housing Admissions and Continued Occupancy Plan, many housing authorities post them on their websites. If they're not online, you can ask the housing authority to send it to you via email. That's often a more cost-effective approach than asking for hard copy, because some housing authorities will charge for copies. So I mentioned the annual plan, and there's a process that goes along with this, and it's mandated by federal law. So all housing authorities have to engage in this annual planning process. It's based on a mandatory timeline that stems from the housing authority's fiscal year, and we'll talk about that in a minute. There has to be public notice and opportunity to comment on the annual plans, and there needs to be a public hearing. Additionally, housing authorities need to consult with a resident advisory board, which is a group of residents who need to have some input on the housing authority's policies. And the plan has to be approved by the housing authority's board of commissioners before it can be sent to HUD. There are some exceptions. Not all housing authorities go through this exact process, but the bulk of them will follow something like this. So a question we often receive is, what's the timing for this and how can I get involved and when do I need to get involved? As I mentioned, it's based off of the housing authority's fiscal year. Interestingly enough, not all housing authorities begin their fiscal year at the same time. So the timing for the plan process is going to vary depending on when your housing authority begins its fiscal year. In any case, the plan has to be submitted to HUD 75 days before the end of the fiscal year. Housing authorities are just like many of us, where they have all these deadlines they need to meet before the end of their fiscal years. In any case, the public comment process, the process that you'll want to be involved in, often begins many months before the end of the fiscal year, and just so the housing authority has a big enough cushion to meet its required deadline. So we'll often see housing authorities begin the public comment process 5 or 6 months before the end of their fiscal year. So that just gives you a sense of when the basic timing occurs. So on this slide, I just have a screenshot from HUD's website that shows when some housing authorities begin their fiscal years. And the idea is just so you can see that some of them start on January 1, some of them start on April 1, some of them actually start on October 1. So it's spread throughout the year. And you can also see when their plan was actually approved by HUD. Another thing you can do is actually download the annual plan that was approved by HUD and see what the contents are. So again, the takeaway point is, not all housing authorities are on the same timeline, but in any case, they're going to start taking public comments many months before this fiscal year deadline. So again, this is a pretty complicated chart, and I won't go over it in detail. But we just wanted to give you a step-by-step guideline so you can see about when certain things happen, when certain steps happen in the annual plan process, depending on, when a housing authority has its fiscal year. As I mentioned, there's a public notice and comments opportunity for the plans. I would actually, if I were you and you wanted to get involved with the plans, get in touch with the housing authority well before the official comment period begins to let them know that you're interested in participating. I'd also ask them to notify you by email once they have their draft plans available for sharing. I think it's really helpful to partner with other local agencies on comments. And another thing that's helpful for the housing authorities is instead of just critiquing the existing language, if you can include the proposed language that you want to see, that's very helpful to them. And we have some sample language if you want to do that you can borrow. I think it's also great to try and meet with the housing authority before the public hearing and share any concerns that you might have about the proposed plans, just because you don't really want to ambush them at the public hearing. So we wanted to run another poll question here. And the question here is, which best describes your involvement in housing authority plans? And you can select all that apply. Have you reviewed parts of the plans? Have you ever met with housing authority staff regarding the plans? Have you ever submitted comments or been to a public hearing? Or have you just never been involved in the process at all? So I'll give you a few more seconds to vote. Again, you can select everything that applies. So I'm really glad that we're offering this webinar today because it looks like almost all of you haven't ever been involved with the plan process, and hopefully this will give you some basic steps for how you could be involved if you'd like to. About 4% of you have either reviewed parts of the plans or have met with housing authority staff regarding the plans, which is great. So I mentioned that there has to be a public hearing on the plans, and that's held before the Housing Authority's Board of Commissioners, and that board needs to approve the plan. Comments at these hearings are often restricted to just a few minutes per speaker, but I think it's still worth going because it's still a way to publicly share your concerns about domestic violence survivors and their access to housing. Another thing to note is that many housing authorities don't provide the board with copies of your comments. And so you may want to send your comments to the board itself ahead of time if you want to make sure that they get to see what you have to say about the plans before they approve them. All right, so now that we've done the basic overview of the plans, I want to get into the specific information that's unique to domestic and sexual violence survivors. And first I'm going to talk about the annual plan, which again is that basic template document that housing authorities have to submit to HUD each year. As part of that annual plan, housing authorities have to make public a description of any services that they're offering to survivors of domestic violence. And they have to talk about services that help victims obtain or maintain housing. And they also have to talk about services they're offering to enhance victim safety. And so you'll want to look at the annual plan and see whether this information is in there, and if not, ask the housing authority, what are you doing to address survivors' access to housing or to enhance victim safety? So I wanted to include an example of how one housing authority has addressed this annual plan requirement that they talk about domestic violence. And I want to say that when I'm offering these examples from other housing authorities, it's not to say that this is the greatest housing authority on earth or that this is perfect policy. What I'm saying is this is an example of a good written policy. Whether it's actually being implemented is always another question. It's always something we have to work on as advocates. But I think it's still helpful to see real-world examples. So this example is from Lucas Metropolitan Housing Authority. And their annual plan states that they're partnering with their local YWCA to administer vouchers for the Shelter Plus Care program. They say that they have flyers in their offices that list domestic violence resources. And they say that they've amended their public housing documents, policy documents, to add domestic violence as an admissions preference to help survivors move up the wait list more quickly. And we'll talk about admissions preferences later. They also state that they've amended their plans and procedures to make sure that they comply with the Violence Against Women Act. And also a really great one, I think, is that they've updated their information packet for Section 8 landlords to include information and resources on domestic violence. So that just makes sure that Section 8 landlords are also receiving information about domestic violence. I also included examples from New York City's Housing Authority and their annual plan. I'm not going to go over this in the interest of time, but I just wanted you to see another way that a different housing authority has addressed the annual plan issues. All right, so that was a discussion of the annual plan, which is, the basic template document. Now I want to talk about the really meaty policies that housing authorities have, which are the Section 8 Administrative Plan and the Public Housing Admissions and Continued Occupancy Plan. Again, these are the big policy documents that housing authorities often use in their day-to-day administration of their housing programs. So a lot of housing authorities have included the Violence Against Women Act, or VAWA, housing protections in their major policy documents already. And that's great. We really, of course, want housing authorities to be complying with VAWA. We don't want them to be evicting survivors or denying them housing based on the violence committed against them. But I think we're at a point now where we can urge housing authorities to go above and beyond VAWA and really address the housing needs of survivors in some creative ways. So some examples of things that I want to talk about in this context are admissions preferences that help survivors of domestic and sexual violence move up waiting lists more quickly. I want to talk about emergency transfers in public housing for survivors who need to relocate for their safety. And I'll also talk about providing some additional protections against evictions and terminations for survivors of domestic and sexual violence. So one question I often get is, is a housing authority obligated to move a domestic violence survivor up the waiting list more quickly? And actually, no, they're not obligated to do that. Housing authorities have a lot of discretion over what preferences they'll use for their admissions. And by the way, a preference is just a way to weight an application so that somebody has the opportunity to get up the wait list more quickly, to move to the top more quickly, and therefore get housing more quickly. And so as I mentioned, there's a significant amount of discretion around these admissions preferences. But one that a housing authority could adopt if it wanted to is a preference for survivors of domestic and sexual violence. One thing that if you decide in your community you really want this preference in order to help survivors obtain public housing or Section 8 vouchers more quickly, you will want to consider what kind of documentation will an applicant need to provide in order to demonstrate that they qualify for this preference. That's where a lot of negotiation happens around these preferences, is on the documentation and verification issues. I want you to know that it can be difficult to persuade a housing authority to change its preferences. It does add a little bit of administrative burden on them because it changes the way that they have to administer their wait lists. So it's important for you to get support from other community groups and residents in order to demonstrate the need and show why you need that domestic violence preference. So I wanted to run another poll here and ask folks, does your housing authority have an admissions preference for survivors of domestic or sexual violence? So I'll give you a few minutes to go ahead and vote on that. And folks are still voting, so I'll give you a couple more seconds. All right, so let's share the results. So a small percentage of you say yes. Actually, my housing authority does already have an admissions preference for domestic violence survivors. 20% say no, they don't, and 63% say I don't know. And if you don't know, there's several ways you could find out. You could call up your housing authority and ask them, or you could look at the Section 8 Administrative Plan or the Public Housing Admissions and Continued Occupancy Plan and look under preferences and see whether there's one offered for domestic violence survivors. So I wanted to give an example of a housing authority that has elected to offer an admissions preference for domestic violence survivors. And again, that's the Lucas Metropolitan Housing Authority. Their plan says that they'll provide a preference for people who have been displaced by domestic violence. And interestingly enough, they offer a really broad range of evidence that you could supply to prove that you're a survivor of domestic violence. And so it's really great that they have all this different documentation. Makes it definitely easier for survivors to provide verification of their status and to qualify for that preference. Another issue that often comes up for domestic violence survivors who are applying for public housing or Section 8 is the fact that they may have negative tenancy, credit, or criminal history that sometimes may result in them being excluded from the public housing or Section 8 voucher program. A housing authority needs to include in its policy documents the criteria it's going to use to assess somebody's application for public housing or Section 8 vouchers. And they have to address criminal history. If they want to, they also can include some screening criteria around credit and tenancy history. As we know, many survivors may have negative credit history due to financial abuse or tenancy history due to damages or evictions caused by the abuser. And so it's helpful if we could get housing authorities to adopt some policies saying that, number one, a domestic violence survivor cannot be denied housing based on his or her status as a survivor. Also, we want housing authorities to have language when they send somebody a letter telling them you've been denied housing. It's great if that letter can include some language about the Violence Against Women Act and tell people about their rights, that they can't be denied housing based on their status as a victim. Another thing that's helpful is if the housing authority could include language saying that their staff will consider whether the negative tenancy, criminal, or credit history was related to domestic or sexual violence committed against the applicant. So in other words, we want an explicit statement in the plan that the housing authority will, if it comes up that somebody has this negative history, the housing authority will look and see whether that negative history was related to violence committed against the applicant. I've included a sample policy here. This is from the National Association of Housing and Redevelopment Officials, or NARO, and they're a housing industry group. And they circulated this policy to their members. And policy basically says, if somebody applies for housing and they've been a victim of domestic violence, they can request in writing that the housing authority consider that history of domestic violence in examining their application. And the policy also says that the housing authority can take into account information about domestic violence committed against the applicant when they're thinking about whether or not to admit someone who has some disqualifying information, such as a poor credit history or damage to a dwelling. NARO also says that their model policy also says that a housing authority can request the applicant to verify the history of domestic violence, but it doesn't specify what someone would need to provide, so it leaves it a little bit open-ended. I've also included another sample policy from a housing authority here in California. I won't go over that in detail, but it's just another example of how people have addressed these admissions barriers that survivors often face when they're trying to get into subsidized housing. Another issue that often arises for survivors is what happens when a family in subsidized housing breaks up due to domestic violence. How is the housing authority going to decide who gets to keep the public housing unit or who gets to keep the Section 8 voucher? Housing authorities should have written policies stating how they're going to determine which family members will get to keep the assistance if the family breaks up due to domestic or sexual violence. Sometimes we see that a survivor might flee the unit for her safety, or the abuser might be ordered out of the unit by a restraining order, and as a result of that, the family has broken up and a decision has to be made about continued assistance to that family. If domestic or sexual violence contributed to the family breakup, housing authorities should prioritize survivors of domestic and sexual violence, and you'll want to get something in writing in their policies to that effect. Another thing that we need to think about as advocates is how do we want custody to play into this? How do we want housing authorities to consider the fact that the minor children are living with one party? Is that one factor that we want them to look at in deciding who will keep the public housing unit or the Section 8 voucher? I'll note that a lot of housing authorities have some problematic policies that need to be updated. And so there's an example of this on the next slide. So let's just assume you've done excellent work. You've taken the step of emailing your housing authority and asking them to send you a copy of their Section 8 administrative plan. And one thing that you are concerned about is their family breakup policy. So you review that policy. And the policy says that if a voucher household breaks up, they will decide which household member will continue to receive assistance by considering several factors, including who is listed as head of household on the voucher, who is currently residing in the voucher unit, and they'll also consider whether you have a signed agreement by the family to assign the voucher to a particular household member. So my question to all of you is, why is the policy problematic, and what would you propose instead? So if you could use your questions box and explain why that policy might be problematic and what you would like instead, that would be great. you can just type in some quick sentences about some problems you see with this. So I'll give you a couple of minutes to do that, and so there'll be a moment of silence while you're typing in your answers. All right, so the answers are starting to come in. So let me pull out the answers and read them back to you. Somebody's saying that the housing authority, they need to consider who is the primary aggressor in the situation, who is the domestic violence perpetrator. It's not enough just to look automatically to head of household, because some abusers may list themselves as head of household as part of the dynamic of power and control. And another advocate has just confirmed that. I'm saying that this policy seems to favor the perpetrator of violence because it's all based on who has power in that household. So you've definitely identified some of the key problems with this policy. So maybe if you have suggestions for what you'd propose instead, if you could type those in as well. And I'll give you a couple minutes to do that. All right, so let's talk about what's an alternative to this. And actually, let me go back to this. And again, it's always this issue about who is listed as head of household on the voucher. It can be very problematic. There's no requirement, and there's often a misunderstanding in that both advocates and housing authorities think that the head of household automatically gets the voucher if the family breaks up, but that's not necessarily the case. The issue of just giving it to who's still residing in the assisted unit, that's very problematic because you may have a domestic violence survivor who's fled for her safety. And of course, the last one, a survivor may be forced to sign an agreement assigning the voucher over to the abuser. So in terms of what you could do instead, first, if there's a judicial decision, and sometimes you might have, as part of a divorce or separation decree, a court ordering the voucher to be assigned to a particular party. But let's assume that there's no decision like that. You'll want the housing authorities to look at a variety of factors. And some examples that people have used in other cases are, as we mentioned, the interest of minor children, the interest of elderly or disabled family members, and risks to family members as a result of domestic violence. You may also want your housing authority to take into account the recommendations of any social service professionals. And as I mentioned before, if possible, you don't want head of household status to be considered. And of course, we want housing authorities to prioritize survivors of domestic violence, dating violence, sexual assault, or stalking, where that violence was a contributing cause to the family breakup. All right, so the next type of policy I want to talk about are policies related to evictions of public housing tenants or terminations of Section 8 vouchers. The Violence Against Women Act states that acts of domestic violence aren't good cause for terminating the victim's lease or voucher. And so, of course, you want your housing authority to have that language in their Section 8 administrative plan and the public housing admissions and continued occupancy plan. We have some good regulations from HUD that further talk about steps that housing authorities need to take in these types of cases. And so I've included the regulations. It's something you could ask your housing authority, can you please revise your plan to include some of that language from the regulations just so your staff knows about it. It's very sad to me, but VAWA doesn't explicitly cover sexual assault survivors right now. I mean, the housing protections don't explicitly cover sexual assault survivors. But you can still ask your housing authority to adopt some policies extending the VAWA housing protections to sexual assault victims. Some other types of policies you might want to ask the housing authority to adopt is you want them to explicitly have something in writing saying that when they're making eviction or termination decisions, they're going to consider the role that domestic or sexual violence played in that program violation. So for example, if you have a client who missed her meeting to go to the housing authority and discuss her annual income to make sure her rent amount is correct, let's say she missed that meeting twice and now she's facing termination because of that. It may be that she reveals to you that she missed those meetings because she was afraid to leave the home. And so if you had a policy like this, you could argue to the housing authority that you need to consider the role that the domestic violence played in her failure to attend those meetings. Another really key policy that's helpful for housing authorities to have is that when they do send out a notice to a tenant telling them they're going to lose their voucher or they're going to be evicted, it's helpful if that notice can include both some language about the VAWA housing protections as well as some contact information maybe for your agency or for your local legal aid program. Another issue that we receive a lot of questions about is how do I help survivors who need to move with a Section 8 voucher? One of the great things about the voucher program is that you can take your voucher and move anywhere in the country where there's a housing authority that administers a voucher program. And so that's a great feature for domestic violence survivors who need to move for their safety. The problem is that there are sometimes limitations on who can take that voucher and move elsewhere. So if you're reviewing your housing authority Section 8 administrative plan, one thing you're going to want to look at is, does it have a policy that prohibits a tenant from moving during the first year of a lease or from moving more than once during a 12-month period? Housing authorities should really have a written exception to these policies for survivors who need to move for their safety. Another good policy to have is one that's stating that the address to which someone fleeing domestic violence or sexual assault has relocated to will remain confidential. And since we're a little over halfway during this training, I'll just remind you that if you have general questions about any of this that I covered today, feel free to submit them in the questions box, and I'll take some at the end. All right, so as I mentioned, in the Section 8 voucher program, you could take your voucher and move anywhere in the country where there's another housing authority. The public housing program, which is housing owned and operated by the housing authority, is a little bit different in that if you're in public housing, if you move out, say for your safety, you typically also lose your subsidized housing, unless, that is, you can move to another public housing development. And so domestic violence survivors often living in public housing need what's called a transfer. They need to be moved to another unit that's confidential, where their abuser doesn't know where they are, or that maybe has some better safety features. Housing authorities in their public housing admissions and continued occupancy plans, they have to have a policy on when a public housing tenant can transfer to another unit. And so in the interest of the safety of domestic violence survivors, you'll want to work with your housing authority to ask that they have a policy stating that a resident can request an emergency transfer when it's needed for domestic or sexual violence. If possible, you'll want them to specify the timeline under which they'll act on that transfer request. Sometimes we see that it's taking housing authorities months to move domestic violence survivors to a safer unit, and that really doesn't recognize the need to get someone into a confidential unit for their safety. So if possible, you may want to specify that they need to do it they need to act on the request within 2 weeks. You'll probably need to negotiate with your housing authority and see what's a reasonable time frame for them. Another issue that often comes up with these public housing transfer policies is what do you need to show as a domestic violence survivor in order to be able to get an emergency transfer to another unit? What type of documentation will be required? And that's something else you'll need to negotiate with the housing authority. Again, the transfer policy should have some confidentiality language saying that the housing authority won't disclose to any outside sources the new address that the survivor has moved to. Another issue that comes up is housing authorities many times, they don't have another public housing unit where the survivor can be saved. In some instances, it might be because your geography is small, or it might be because the abuser has family members and all the public housing developments throughout the city or town. In those cases, the survivor may just need to move outside of public housing entirely. And so one thing you could advocate for is that in those types of situations where there is no other safe public housing unit, is there a possibility that a domestic violence survivor in that case could be issued a voucher instead and allowed to move to a unit of her choice? So let's have another policy discussion. And let's say that you've been a good advocate and you've obtained a copy of your housing authority's public housing admissions and continued occupancy plan. And one of the things you're going to want to review in here, again, is their emergency transfer policy. So the plan states that you, as a public housing tenant, can request an emergency transfer to another public housing unit if you have been a victim of crime. But to qualify for that transfer, you have to give the housing authority either a letter from a police officer or a district attorney recommending that you be able to move someplace else. And so my question to all of you is, what suggestions would you make to improve this policy? So I'll give you a couple minutes to respond in the questions box. And there'll be a little silence while you're responding and I review your answers. So feel free to be as creative as you like and let me know what you do to make this better. All right, so I'm getting some responses. And somebody points out that not all victims involve law enforcement. And instead of just restricting the documentation to a letter from a police officer or district attorney, you should be allowed to provide documentation from a domestic violence service provider. So you'd want to suggest that to the housing authority, that they allow that additional documentation for people who need to move. The other issue is this talks about someone who is a victim of crime. And that can, be difficult because the question is the housing authority going to recognize all forms of domestic violence or stalking as a crime? Something that we may recognize as a crime or criminal behavior may not necessarily under the law be a crime, but still could be very dangerous to our clients. So perhaps you'd want to ask the housing authority to specifically state that a public housing tenant can request a transfer if needed due to domestic violence, sexual assault, or stalking. Just to make clear that, it doesn't necessarily have to be someone who is charged with the crime or is cooperating with police, but somebody who's experiencing domestic violence or stalking should be allowed to request this emergency transfer as well. Somebody else points out that you would want to specify the time frame in which somebody would be able to be moved if they qualify for this emergency transfer. So thanks for those responses. And let's move on to documentation issues, which just came up. So we've talked a lot about documentation today. And it's really important to work with the housing authority to determine what types of documentation it will accept to prove domestic violence or sexual assault or stalking. Now, under the Violence Against Women Act, there's some federal protections against evictions and voucher terminations. And the law clearly sets forth the type of documentation that can be required. A housing authority has to accept HUD's self-certification form, a police or court record, or a statement from an attorney, medical professional, or domestic violence advocate. And so, that's for the protections against eviction or voucher termination. But there's this other issue we talked about. So we talked about an admissions preference to help survivors move up the wait list more quickly, or emergency transfers in public housing. In those types of instances, you're going to be able to influence the housing authority about what types of documentation is acceptable. Some of you already identified the fact that it's problematic just to have law enforcement or the courts be the sole source of documentation. You'll want to review documentation and make sure that housing authorities are allowing survivors to provide a variety of different ways to prove domestic violence and sexual assault, such as the advocacy letter that somebody just commented on earlier. So I wanted to share some advocacy tips. And again, feel free to submit questions on anything I've covered today, and we'll get to those at the end of the training. In terms of getting started with housing authority advocacy, one thing that you'll want to do is just request a meeting with your housing authority, perhaps with the executive director, in advance of their annual plan process. You want to give them plenty of time to think about this, to discuss some policy changes that could help survivors of domestic and sexual violence. When you have that meeting, actually let me go back, one thing that you can bring with you is we've prepared an implementation survey that you can ask housing authority staff about. So for example, we've included this in the materials that were emailed out today, and you want to know, and you want to give the survey to them. So you have a range of questions to ask. For example, have they informed tenants about their rights under the Violence Against Women Act? In what ways do they notify tenants of their rights under VAWA? Do they give it in a packet for new tenants? Do they have it in their leases? If there's an eviction notice, do they include information about VAWA? You can ask them, have they updated their plans in response to VAWA? And a big one for us as advocates to ask about is, have they trained their staff on domestic violence? It can be really beneficial to provide a housing authority with training on the basics of domestic violence, on the dynamics, the common myths, what constitutes domestic violence, safety concerns, and safety planning. So this survey is a great way to open up the conversation and also for you to gather some more information about the housing authority. We've done this in California, where we sent this out to all the housing authorities in our state, and it was a great way for us to see where we were at in terms of were housing authorities taking any steps to address the housing needs of survivors, who was doing a good job, and who needed some more help. So that initial conversation can be really important in getting the ball rolling. As I mentioned, housing authorities need to send out public notices about their planning process. Sometimes they just publish that in the newspaper, and I know many of us don't look at the paper every day. So you can ask your housing authority to notify you maybe by email when they're planning to begin the process, so that you have a lot of time to review the plans and see how they address domestic violence. Let's say you missed out this year on the housing authority planning process. I know many of you are busy and it might have slipped right by. You can actually still look at the recently approved plans and look at how they address domestic violence and make your plan for next year, and meet with the housing authority and start talking about next year. I think a key thing to remember is that housing authorities are often more responsive to this conversation if you talk about the services that you can offer, such as if you tell them, if you become aware that somebody's experiencing domestic violence in public housing, you can call our hotline and refer them there. Or we're really happy to train your staff on how to respond to domestic violence in public housing. All of those things can be really helpful to building a relationship. Finally, if you're able to get the Housing Authority to adopt some great new policies on domestic and sexual violence, a really key next step is figuring out how they're going to notify tenants and community agencies of those policies. What are they going to do in terms of outreach? Are they doing linguistically appropriate outreach? And how could you possibly partner with the Housing Authority to make sure the word is getting out about these new policies and protections for tenants in public and subsidized housing? Here's my contact information. As I mentioned, I'm happy to take questions by phone or email. Also, right now, if you want to submit questions via the questions box, I'm happy to answer them. We have a website specifically geared toward domestic violence and housing issues, and the URL is here. So we have a couple minutes for questions, so I'll take a couple that came in, and then I'll turn it back over to Phyllis. So somebody mentioned the fact that in public housing, tenants continue to be required to pay rent while they're waiting for an emergency transfer, even though it's no longer safe for them to live in the public housing unit. So what could be done about that? One thing to discuss with the Housing Authority is whether they'd be willing to adopt a policy that permits a temporary suspension of rent while the tenant has vacated the public housing unit. And the policy would explicitly state that somebody continues to be a public housing participant when they vacated due to domestic violence. I think it's really important to have something like that in writing because, as many of you know, otherwise, if your clients stop paying rent to the Public Housing Authority, they are no longer considered to be participants in the public housing program. So I would just explore with them whether you can get something in writing, creating sort of a suspension of rent payments for those public housing tenants who had to vacate the unit due to domestic violence. Another question came in is, again, this question about what can we do to help survivors just get into public housing or Section 8. And I'll tell you that in many jurisdictions right now, the waiting lists are very, very long. There's just not enough supply for the demand that is present in many of your communities. I think talking to the Housing Authority about a domestic violence preference is a good first step that can help people move up the wait list faster. Another option is to explore maybe whether they're willing to set aside 15 or 20 vouchers a year just for domestic violence survivors. And maybe these can be survivors who are referred from your program, who have already been screened, who are ready to go and need to move immediately into the voucher program or public housing. So it's just exploring with them whether they might consider a set-aside program like that. Other housing authorities have done it. It's been quite successful and has helped survivors move more quickly. I will say that that takes a lot of advocacy and community support and alliances. But in some jurisdictions where there's not a lot of affordable housing, it can be a huge benefit for survivors. So with that, I'll turn it back over to Phyllis.
Thank you, Malia. That was really, you covered the waterfront, and that's great, and it looks like our work is cut out for us. I'd like to thank everybody for joining us today and being willing and interested to learn more about how we can make a critical difference in the lives of survivors. Without a place to call home, oftentimes they stay for a short time at a shelter and then return. And housing and shelter services, actually both, are in critical need in most places, certainly in Ohio. Action Ohio is committed to continue our work on housing issues. It seems to be getting more and more attention these days as we realize that economic self-sufficiency is critical, not just with housing but with other issues as well. But housing plays a very important part of it. As you work with clients, we welcome your sharing specific housing problems with us, and in turn, that will help shape future training events we do, future other projects work, and gives us also some fuel with which to make contacts with people like Malia and ask more questions and provide access to more resources. So please feel free when you've got a real headache of a problem in terms of helping a client. We'd love to hear about it, and maybe there's something we can do or connect you with someone who could play a role in solving that problem. Thanks again for joining us, and have a great holiday season. Thanks.